Good evening, everyone. So we have, I'm sitting waiting for motions for summary judgment, but we've actually had some movement on the Texas docket where Jed Wallace is he's filed a complaint against Blake Lively. Blake Lively has fired back with motions to dismiss, and we just had the judge's ruling on that now, and he has dismissed the complaint. So the motion to dismiss has been granted without prejudice. I'm not going to go through the whole document because it's a lot of background which we already know. But essentially, the main points are that Jed Wallace, in the personal jurisdiction argument, Jed Wallace sort of stated the claim that because Lively had filed a Rule 202 petition in a Texas court before adding Jed Wallace to the New York lawsuit, that effectively meant that Texas had jurisdiction over Lively. But the Rule 202 petition was filed in a state court, and essentially the court says, well, you can't. It doesn't extend itself to a federal court. So it also says here, in response, defendant argues that the Rule 202 petition is not an original action and that she did not otherwise litigate extensively on the merits because defendant non-suited the petition 14 days after filing it without ever serving plaintiffs. The court agrees. So as far as the and this is the other bit as well, like I say. So the Rule 202 petition is a state court. It was a state court thing. And clearly here it says a Rule 202 petition for pre-suit discovery is so distinct from a traditional lawsuit that the majority of Texas courts to consider the question hold that a Rule 202 proceeding may not be removed to a federal court. So that's the first argument out. Let's have a look. The judge also says defendant's Rule 202 petition does not amount to litigating actively on the merits, which would thereby surrender any jurisdictional objections. The Rule 202 petition was only pending for 14 days, and defendant never served plaintiff Wallace before non-suiting the petition. Therefore, the court finds that the plaintiffs have failed to demonstrate that the defendant's Rule 202 petition subjects her to the court's personal jurisdiction. So if you remember, Jed Wallace, he was never served because Lively's process servers sat in the car honking horns. So, yeah. The Calder effects test. The plaintiffs also argue that the CRD complaint, upon which this lawsuit is based, was aimed at Texas, where both plaintiffs reside. So that's obviously Jed Wallace and Street, and they undoubtedly caused harm. Two mentions of Wallace in the draft complaint specifically state that he is based in Texas. And defendant Lively interprets this as an application of the Calder effects test, and so the court will analyze it as such. Okay, the Calder effects test permits courts to exercise specific personal jurisdiction over an author or publisher who aims a story at the state, knowing that the effects of the story will be felt there. Sorry, just going to. In comparison, plaintiffs allege that defendants' defamatory statements were aimed at Texas, where both plaintiffs reside, and they undoubtedly caused harm in Texas, because 2 mentions of Wallace in the draft complaint specifically state that he's based in Texas. However, stating that plaintiff Wallace is based in Texas served merely to supply background biographical information and is even less prevalent than the level of detail alleged in the Field article. Furthermore, plaintiffs do not allege that defendant relied on any Texas sources in writing the CRD and draft complaints. Lastly, plaintiffs have not sufficiently alleged that the defendants directed their actions towards the forum and knew their effects would be felt there. Plaintiffs argue that defendant published a defamatory CRD complaint and draft complaint and provided the documents to the press, who promptly republished them, as she hoped and foresaw, in Texas and elsewhere. However, while the CRD complaint was allegedly shared with the New York Times and was republished all over the world, including in Texas, there is nothing to indicate that the article was targeting Texas readers, as distinguished from readers in other states. Furthermore, the CRD and draft complaints both focused on events taking place outside of Texas. Based on the foregoing, the court finds that the defendant's actions do not subject her to the personal jurisdiction of this court under the Calder effect test. And then we've got information and beliefs statement. So, the first part, the other 2 parts were predominantly around the jurisdictional issues. This is around the failure to state a claim. Lastly, plaintiffs contend that on information and belief, additional defamatory statements about plaintiffs were made by Lively at SXSW in Austin, Texas, and later in Waco. More specifically, plaintiffs allege that when confronted by a Texas resident, who we all know to be Colonel Kurtz, who stated that Blake lies and referenced justice for Justin, Lively never admitted that her statements were false, but rather allowed her lies to stand. They further allege that defendant made additional defamatory comments about plaintiffs at a hotel in Waco, and that further discovery may reveal whether she made any additional defamatory remarks about plaintiffs at her promotion of the film at the Texas Book Bonanza event. I'm not sure she would have mentioned Jed Wallace at the Book Bonanza. I'm not even sure Jed Wallace was brought on. I don't think he was even hired at the time of the Texas Book Bonanza event. I don't know. Defendant argues that information and belief statements cannot satisfy plaintiff's burden to plead facts that establish a prima facie case of personal jurisdiction at the motion to dismiss stage. As to defendants' alleged silence in response to a fans, I don't think Kurtz is going to enjoy being called a fan. Silence in response to a fan's confrontation at SXSW. Defendant argues that silence alone does not constitute a defamatory statement. The court finds that these allegations are insufficient to support any claim, including to establish personal jurisdiction. To be fair, I can't argue with the logic and the reasoning here. It is plaintiff's burden to establish personal jurisdiction when faced with a motion to dismiss for lack of personal jurisdiction, and they have failed to present any affidavits, interrogatories, depositions, oral testimony, or any combination of the recognized methods of discovery that the court may use to determine the jurisdictional issue. While the court recognizes that plaintiffs may not have had extensive opportunity in the present case to conduct discovery, the issues underlying this case have been under extensive litigation in other courts for nearly a year, and yet plaintiffs failed to provide the court with any greater level of detail beyond the speculation that, on information and belief, defendant repeated the defamatory remarks while in Texas. Accordingly, the court concludes that plaintiffs have failed to establish that the defendant is subject to this court's personal jurisdiction. When a court finds it lacks personal jurisdiction, it may dismiss the action pursuant to Federal Rule of Civil Procedure 12b-2. Because the court's finding of no personal jurisdiction resolves the motion to dismiss, the court need not address defendant's other bases for dismissal. For the reasons set forth above, the court grants defendant's motion to dismiss for lack of personal jurisdiction pursuant to Federal Rule of Civil Procedure 12b-2. Plaintiff's claims are dismissed without prejudice. So, I don't know what's going to happen next. Now, we already know Jed Wallace is dismissed from Library's claims in New York for jurisdictional issues as well. So now she's been dismissed from his claims in Texas for jurisdictional issues. Now, I've already predicted, if I was to say where I think Lively could potentially file a claim against him, I don't think she's going to Texas. She wanted out of Texas. I think she's going to go to California. And I've covered that in great detail when I did the order on Jed Wallace being dismissed from her claims. However, I think Jed Wallace is likely to amend his complaint and include some of the things that the judge here has asked for: interrogatories, depositions, some discovery that ties her more closely to Texas and nails down his complaint against her. Or he may just choose not to file anything at all. We will see. All right. I will keep a lookout for the motion for summary judgment. But have a good evening.